excited to have a dear friend. We are excited to have a dear friend with us, a friend of Rhonda's Promise, Attorney Deere. She's going to talk to us tonight about probate and estates and wills. And so I'm just so excited for this conversation because we have to be prepared. And she's really good about bringing this to the forefront, especially for our women of color. And I'm excited to share with you her presentation this evening and invite our friend back. You have the floor.
Thank you very much. Just to confirm, you can hear me okay, and you can see me and see my screen okay?
Yes, ma'am.
Perfect. So the question I have up is something that may seem a little bit ubiquitous, right? We're all here and we all have a destination, right? It's a part of our life cycle. But some people have to deal with it in terms of it being a burden or it being a streamlined, efficient process where they get to grieve without having to deal with too much stress. And that's one of the things that I aim for when it comes to helping my clients and doing these type of educational presentations to my community to help everyone to make sure that ourselves and our families have the latter experience where there's space to grieve, but things are put in place in the right way, no matter what type of estate, how much money you have. We can still make sure that we plan accordingly and take care of each other and take care of our families and leave a love letter, if you will. So I wanted to bring this to your mind in terms of this question and what do you know about it? Because a lot of times there are a lot of myths involved with probate. A lot of what we see and know is what we see on TV. Um, some people in our generation or older, maybe they've known about someone passing away, but they haven't had to deal with it directly, even if it's a family member. So I wanted to make sure that this was in your mind as we move forward, because like so many things about this life, we do have to move with the end in mind sometimes. And I talk about that with my clients. And it's not something to be afraid of. The process and what happens when it comes to the law shouldn't be something that we're afraid of either. So this whole session is about empowering you to know exactly how things should go, and then empowering you about estate planning so that you are empowered. But remember, each of you represent a community of people. So you're going to be sharing this with other generations so that they are also empowered. And I hope that that's what you take away from our session today. So I hope you're ready for with questions, and we're gonna go into this session with an open mind, but also take down notes because you're also and jot down your questions because you're also gonna be given the opportunity to meet with me. So more information about me. I'm a Florida lawyer. I'm only licensed to practice in Florida. And that always reminds me about my disclaimer during this session. I am not your Florida lawyer until you hire me, right? And a lot of the information I'm giving you today is general legal advice. It is not legal advice for you to rely on unless we are in an attorney-client relationship. And this session does not constitute that. So I just want to make sure everybody's clear on that. In addition to being a certified technology lawyer, I know how to deal with digital assets and things like that. My practice focuses on estate planning, probate, trust administration, and most recently, I've added elder law as a part of my practice area. So what's estate planning? Because when you throw that stuff around, a lot of people think it's just a will. But in fact, estate planning is a lot more than that. Yes, it traditionally focuses on wills and trusts, but mainly it focuses on the building up or accumulation plus the preservation, and then, organizing the distribution of financial assets as well as all your worldly possessions. So that includes the spoons, the purses, the couches, whatever you have as far as your worldly possessions. Not only that, estate planning aims to protect your material wealth from probate, and it also can be a good way to minimize taxes for you and your loved ones, or your estate and your loved ones. So what about probate? Probate is the process by which, after someone passes away, there is a legal process that actually converts or transfers the assets that someone owns in their name to their heirs or beneficiaries, whether or not they have a will. Probate usually and most often involves the courthouse. So someone going to court, filing a case, and having to ask the court to give them permission to do stuff with the decedent or the dead person's stuff. The other thing that probate does, it is make sure that the decedent's debts are paid. So any creditors that they may have, if there are assets in the estate, it makes sure that those assets are paid. It also is a place where disputes are resolved, right? You know, people who claim that the will is fake and things like that, or they believe that they're entitled to money because they're a beneficiary some type of way to the person who passed away. And then finally, probate is a place where the distribution occurs. You know, the funds or the assets are transferred to the people by way of a court order to all these places. Now, probate, the place itself, the courthouse, the probate section of the court, doesn't only deal with death, it also deals with guardianship. And that's something that I talk about with my clients when we're talking about estate planning in general. Because for me, estate planning is not just about death, it's about the living and how to protect your assets while you're alive as well as after you've passed away. So that is probate in a nutshell. But I wanted to go more into the probate process because many people think that because you have a will, you don't need to go to probate court. But the sad fact is, if you don't have anything, no will, nothing in writing, no paperwork saying what happens to your estate, then your family has to go to probate as long as you die with assets in your name. If you pass away and you leave a will behind and assets in your name, like a house or a piece of land or even a car, you still have to go through probate, depending on how your estate is set up. Now, I hope that just that last statement alone generated lots of questions for you. You probably know of all these different types of scenarios. I'd be happy to answer those questions at the end. But let's really look into what the process of probate after someone's passed away really looks like. So if you die without a will or with a will, you have to go through the probate process in your state. Some states and counties have easier processes than others. But no matter what, you will have to do this process everywhere in the world where the dead person owned property. For example, you have a house here in Palm Beach County in Florida, but you also own a piece of land somewhere in Georgia or Alabama or New York. As a Florida resident, you have to start the probate case here, but you also have to go to Alabama, Georgia, and New York if you have property there and do the whole probate process there as well. Now, this might be surprising to some people because they're thinking, well, if we do it here, we don't have to do it there. Sometimes people don't even tell me about the other estates or the other assets that they have, the decedent had in other states, because they're thinking, that doesn't count. We're only dealing with the Florida stuff. It counts no matter where you are in the world. So the timeshare in Hawaii, the piece of land that you have in Spain, the family house in Jamaica or Trinidad or Haiti, those are all a part of that person's estate. And they have to be probated just like everything else. Now, everywhere is different, but it doesn't mean that it's not going to be counted here. So let's talk about what happens during the probate process. First of all, if there is a will, we have to authenticate the will, like in the movies where they talk about the fact that this was a forged will and they forced somebody to sign it on their deathbed or whatever, or got them inebriated and they signed a will that they weren't supposed to sign. Well, in Florida, there are specific things that a will must have. And it matters if you signed it in Florida versus another state. A Florida will is different from a New York will, a Georgia will, or an Alabama will. All of that, if it's outside of Florida, you have some splaining to do. You have extra work to do to tell the court that it was valid there as well as valid here. So be careful of that. If you're a new resident to Florida and you have out-of-state wills and out-of-state trusts, definitely consider updating those documents as well so that they reflect Florida law and have less issues for you and your family as things go by, as time goes by. Other than authenticating the last will and testament, you also the court also appoints an executor, but in Florida that's called a personal representative. And a personal representative might actually be posting bond, which basically says you have to buy insurance to assure the people, the beneficiaries in this case, and the court that you're not going to abscond with the money. Here's a good example of that. Y'all remember Chadwick Boseman? I'm still sad. Chadwick Boseman was married 2 months before he passed away. And where he lived, his wife technically should have gotten everything because they didn't have any children. But his parents came into the case and they settled by splitting his $36 million estate. If he had lived longer, he would have gotten so much more money. But what was important about that case that I think a lot of people overlook was the fact that Chadwick Boseman's parents required her to file a bond, to post a bond in order to be the executor of his estate. They just didn't trust her and made a big fight. And I think she definitely relented and gave them half of it just to shut down the drama. And sometimes that's what it boils down to when we're talking about probate and resolving an estate. But posting a bond is the insurance that is important for some people. Then you identify the creditors. That's in the middle right there. And one of the things that you have to do is find out who the creditors are. Who does this dead person owe money to? And then you have to tell them about it. And in Florida, there is an actual creditor period. You have to give the creditors a certain amount of time to come back and say, hey, they owe me money, so I have a valid claim to this estate. Now in Florida, there's a lot of different timelines floating around, which is why most of the time when you have probate in Florida, you have to hire an attorney to help you with this stuff, because Florida probate rules and the Florida statutes are very specific about what is in and what is out. And there's usually a 90-day period, 3 months from the time that the creditors are notified, that basically nothing really happens in the estate, because the creditors have to be given the amount of time required to file their claim. But the important thing is, after that 90-day period has ended and they file it late, they're not entitled to anything from the estate because they have waived their right to file a claim because the creditor period has expired. Then there's determining the date of death values. This is important because a lot of times the value of the certain assets goes up and down, like a brokerage account or even a piece of land. Those types of things may have variable values. And what we definitely want to do is to make sure that at the time of the death, we give the court an inventory of exactly what the person owned and what the value of that was at the time of their death. And that's all part and parcel with figuring out where the assets are, all the different things that they may own. Then certainly paying those debts off. Now, I know the question that's going to come up is, what if there's no money in the estate? Then the creditors don't get any money. This brings up another important point. Do not pay dead people's debts if they're not your own, other than a mortgage debt for a house that you're supposed to inherit. Definitely you might want to not bring foreclosure in the mix in a probate case. But if there's an asset like a credit card or a Macy's card or Home Depot card that your name isn't on, you didn't co-sign for it, please don't pay that debt. That is supposed to be processed properly through probate, and they are required to make a claim just like everybody else. If there's not enough money in the estate, then they don't get any money. But if they have a timely claim and a valid claim and more money comes into the estate, they might be entitled to it. But make no mistake, there's a hierarchy as to who gets what in a probate case. And that is something that an attorney can walk you through as well. And in case you didn't know, when somebody passes away, you have to file a final tax return for them. But if their estate is worth more than the federal estate tax limit, then you also have to file a tax return for the estate. And sometimes people file tax returns based on the amount of income that the estate ends up getting during the probate process. So that's just as important. The IRS is always involved when it comes to probate. And then finally, distributing the assets. Basically, the court is going to say, these people are entitled to whatever is in the estate, either based on the law of intestacy or the will. To be clear, the law of intestacy means whoever is supposed to get it, who is related to you. And sometimes that sends shivers up people's spines, knowing that their hard-earned wealth is going to go to some family member that they don't like, or who may have stolen from them, or was their abuser. All of those things should be something that you should really keep in mind in terms of who gets what from your estate. Remember, you're entitled to disinherit anybody that you want, except your spouse, but we can go into that in more specifics later. But kids they're not entitled to anything. You're responsible for them until they're 18, and then that's it. You can disinherit them if you want and skip them and go to your grandchildren if you feel like. But that's really important for everyone to understand. If you're going through the probate process, the court order is what governs it, not what you feel like as an executor to give so-and-so. You can't go in and just take out money out of the estate and give it because the dead person told you so. It doesn't work like that. So you want to make sure, in this case, you have to follow the law if it's going through probate. And the people, whoever is listed as a personal representative in Florida, they're personally liable. That's why there's a bond issue. They're personally liable for whatever they do in that probate case. So if you give away money that you weren't supposed to give away, that's your money that you have to give back. So I always caution people with that to make sure that they're picking the right people for these positions. Now, this chart is really important for people to understand because we just talked all about probate. But guess what? Assets in someone's estate doesn't mean that it's going to go through probate. Yes, if you have a will and if you have no will and it's in your name, more often than not, it's going to go through probate. But here are the exceptions to that. So I always ask these questions when we're going over assets of the dead person to make sure that we understand what's in and what's out. I always give my clients a probate questionnaire. And I have them write down everything, including assets that may have beneficiaries, because that means to me, this is not in. So here's the first question. Does it have a joint owner? Yes, then the joint owner inherits. Now, here's my big red flag cautionary tale about this. People think that they should put their bank account in somebody else's name, even their spouse's name, because the spouse will know what to do with the asset and they're going to do the right thing. How many people know that people change, relationships change, and the people who influence the people around you also change and may influence them in the wrong way or in the way that you wouldn't approve of? Let's put it that way. Wrong is relative, right? So consider this. A mom is really, really close to her son's wife. And the mom said, okay, I'm going to put this account in your name because you're a banker and you know what you're doing with money. and you're going to take care of all of my stuff. But her will says everything that I own in that bank account goes to such and such. What do you think is going to happen? That money is only going to go to the daughter-in-law, and she doesn't have to do anything that the will says, because a joint owner is the one who inherits. And if she's no longer married to that person's son, then she probably doesn't have any obligations further either, because that asset is not a part of marital property or anything like that. So really consider that not only if you are making that type of decision that there are all these other things involved, but consider also that joint owners means joint everything. You're being attached to somebody else's life, their creditors, their bankruptcies, any bad thing that might happen, any emergency that might happen in their life, your assets are not up for grabs for this whole person. Not only that, if you put everything in their name, you're essentially guaranteeing that you're disinheriting anyone that you may put in a will, or you may say you want them to get something. So I don't recommend joint ownership unless it's a very narrow circumstance, because like I said, people change and you can't control everybody else. You can only control yourself. The next question is, does the assets have beneficiaries, including a pay on death or POD and transfer on death designations? And if the answer is yes, then those designated beneficiaries will inherit. So the example for that is a bank account, and you put a beneficiary on it. At the time of the death, it triggers that transfer. It doesn't matter if they have to file a claim, fill out paperwork, and all of that. Once that person passes away, that asset is no longer in their estate. It already transfers invisibly to the other party as a beneficiary. And as long as they can show up and show all the right stuff, then they get it, and it doesn't become a part of the estate. So it's not going to probate. Same thing with any asset owned by a trust or names the trust as a beneficiary. Now, trusts are really magical things, because what they do is avoid probate in many different ways, but they also help people while they're alive with a trustee. In this case, if the trust owns it, then it's not in the person's name at the time of the death. And if the trust is a beneficiary, then it magically transfers to the trust upon the death. So it's not in the estate and it's not a part of probate. Probate assets, on the other hand, is if it's just in your name alone with no TOD or POD, no beneficiary designations, it all becomes a part of the probate court process. And that's if you have a will or if you have no will. If you have a will and it's valid, then the will beneficiaries will inherit. But if you have no will, and your next of kin will inherit. So I wanted to just point out right here that a big part of what I do as an estate planning attorney is I point out this holistic view of wealth and legacy, that your estate planning shouldn't just be about who gets what and how much money and where they're, what's going to happen with the money and things like that. It's really also about just how you can transfer what you know, what you've done in this life, the things that you want to transfer to your family, your core values, your wisdom, the contributions to your community. All of that is important, not just the finances. So I want to make sure that you also consider that as you're thinking about estate planning and what's going to happen to the legacy that you leave behind. Here's another thing that a lot of people don't think about either. I mean, we're on Facebook, right? We have digital lives. And a big part of what people leave out of their estate planning is what's going to happen to my iCloud account? What's going to happen to my Gmail account? What's going to happen to my Shopify account? What's going to happen to my TikTok content? What is going to happen to my Facebook account and all of the people that I'm connected to on there? How do I account for all of those things? So more and more, our digital lives reflect all of those values, memories, legacies, and assets and money. People have whole businesses, multiple businesses, building straight empires online. Think about NFTs and all the money that's being made on digital assets right now. I mean, people buy, wings on Roblox, and that's your actual property. So being able to help people with crypto and things like that and how they're going to transfer and control all of that is just as important. These are just some of the things that I talk to my clients about, just to make sure we have all the bases covered. What are you going to do with all of these things? People don't even know what happens to their Audible account when they die. So all of these things are truly still important to you and should be important to the people that you leave behind to manage your estate. So we talked about probate and things like that. I wanted to talk about how these things can be controlled, how you can actually take care of your family. And one of the ways that you can do that is a will. Everybody needs a will. Say it with me. Everybody needs a will. If you're over 18, you're supposed to have a will. Think about it. So many of these kids, okay, think about the 18-year-old who's like making $17,000 on online gaming a year or a week or a month. They're adults making money, and their assets may go to their family members. If they're unmarried, it's going to go to their parents. Do you think, and sometimes both parents aren't the ones who are entitled to this money. So think about all of that. In Florida, a will is the only thing that governs your assets in your name without beneficiaries at the time of your death. So this is what a will does, right? It controls the transfer of property, and the laws of each state set the formal requirements for it. Here's some more bullet points about that. You must go to court to probate a will, but only if there are assets in the estate. Some wills can create a trust called a testamentary trust. And you get to decide in the will who gets your property instead of Florida or the government deciding who gets your property. You also get to name the guardian of your minor children in a will. And it talks about who has to pay the taxes, you or your beneficiaries. And it declares what happens to all of your assets, including whether everything that didn't go into your trust must go into your trust. And here's the thing that a lot of people don't know. Even if you have a trust, you still have to have a will. So when I talk about a trust, more often than not, I'm talking about a revocable living trust. And that's usually an agreement between you and your trustee. More often than not, that trustee is going to be you. So it's an agreement between you and yourself to manage your assets during your lifetime, and to your successor trustees to distribute the remaining assets at the time of your death. Here's some bullet points for a living trust or a revocable living trust. Trust assets get transferred directly to the beneficiaries, but it doesn't mean that your trustee isn't required to pay your creditors as well. They still get to do that. But the beauty of it is you get to do that outside of the lengthy court process. You tell the court that there's a trust, but you don't file the trust. It remains confidential. You file the will, but the will only says, whatever I have in my name at my death goes to my trust. Nobody knows anything else about your trust. It preserves your estate for your children should you pass away and the surviving spouse gets remarried. How many of you have heard of the surviving spouse getting everything that the deceased spouse got, but then they remarry, and now their new spouse that they're booed up with gets all of the stuff that the old spouse who died gets? And that means if the new spouse has children and the surviving spouse passes away, the new spouse gets everything, and the children of the prior marriage don't get anything. So that this asset, just the assets and the money and the wealth gets moved to a different family that had nothing to do with its creation. It's truly sad. And there are ways that you can protect that from happening, especially with a trust. And with a trust, it's either in or out, right? If it's not in there, then you're gonna have to go to probate and have everything transferred to the trust. But the trust is a great way to protect assets for children. Think about it. If you have somebody who is 10 who is supposed to get an asset under the trust, you can set up your trust so that they don't get anything until they're 25. And until then, it's for their health, education, maintenance, and support. The trust pays it for you. When you get to a certain age, then you get your money. Before then, it's not your money. And even when it's time to do the distribution, you can set it up so the trustee says, let me see what's going on in your life before I give you any of this hard-earned money that's been sitting here waiting for you. Are you going through a divorce? Do you have addiction issues? Are you going through bankruptcy right now? I'm gonna hold on to this money until you get your back on your feet. I can help pay for you, but I'm not putting cash in your hands. You can set the trustee up to do exactly that. And that's one of the great things about trust. It's not everything that I can go into, but it definitely can also protect you if you become disabled or incapacitated. The reason for that is if the trust owns it, then your successor trustee can manage all your assets, pay your bills, take care of you, make sure everything is okay until you get better. Or if you don't get better and you pass away, at least the trustee is there to do whatever they need to do to make sure your beneficiaries are taken care of as well. So make sure that you start your estate planning. It's not hard. It does require you to think about this stuff, which is important. Many people say you should think about death at least 5 minutes a day. It helps you to be calm about it. But one of the things that's really important is work with someone who doesn't do cookie cutter. Everybody don't need a trust, but everybody needs a will, some way, shape, or form. But get an assessment of what your needs are from an experienced estate planning attorney and start right away. Even without a will, at a minimum, these are the following things that you should consider as critical needs for taking care of yourself and your loved ones. Obviously, we talked about the revocable trust and just how awesome it is for taking things out of the lengthy, expensive, and often stressful probate process. Then you should also consider, every trust usually has a will, but if it's not, you should have a will. You should have a living will. Now, a lot of people come to me and say, I need a living will. That's not what you need. That's not usually what you're talking about. They're usually talking about a last will and testament. A living will in Florida is what governs what happens to you as far as healthcare decisions at the time of your death. That means you're in a coma, you can't come back. What's going to happen as you're dying? You get to decide that. That is something that's a very important right that you have to put down on paper. You should definitely consider a power of attorney, which usually handles your financial assets, as well as a healthcare surrogate or a healthcare power, which usually handles your healthcare and your healthcare information as well as your healthcare decisions. In Florida, you can pick a pre-need guardian who you tell the court ahead of time who you want to take care of you should you become incapacitated and a guardianship is needed. And then if you don't have a will, make sure that you have beneficiary designations on all of your accounts. Remember, you can pick a trust or your estate as a beneficiary. Nothing's wrong with that. Remember, traditional estate planning is found everywhere, from the simple will that many have downloaded from the internet to living wills that are marketed online as well. But some of these documents only address a few of the needs that families have. And even living trusts that I've seen drafted by other attorneys only address the issue of probate avoidance. They don't necessarily going into how to protect it from remarriage, how to keep the money in the trust to protect the children, or even death tax protection. Very few protect families from the devastating impact of nursing home costs and Medicaid planning. So when you're thinking about an estate planning attorney, definitely check them out, right? Google is our friend. But make sure you're also considering flat fees versus hourly fees, and I recommend flat fees. And then if you're going to have a trust, remember, if it's not in the trust, then it's going to probate. So if it's not in, it's out. And when it's in, that's called funding a trust, making sure that the trust owns it or will own it at the time of your death. Then make sure that you're thinking about legacy planning. What's going to happen to this heirloom in my family, this personal property that may not be fought over, but you really want to give it to someone who will cherish it. Or you want to make sure that the books that you've written are being passed on properly, or the collection that you have is being distributed or donated to the right museum or college or university. Those are some of the things that a lot of people don't consider when they're talking about estate planning. And they leave these things in the hand of people who are grieving or who are just trying to make a fast buck so they can get out of this whole process. Make sure that you're getting instructions and guidance. You're being listened to when you're talking to an estate planning attorney. And then as much as you can, avoid online, because even every one of those online places usually offer you an attorney to talk to. And sometimes you're not getting someone who's listening to you or who is as knowledgeable about Florida law as you'd like them to be. So I know that I brought up a lot of questions, but most of all, I want to make sure that people are thinking about this, that you're really thinking about this every once in a while, even if it's just to say, okay, let's do things in stages. Let's work on our estate planning. Let's work on our funeral arrangements. Let's work on getting these beneficiaries added to these accounts if we need them to be. But make sure that you're working on getting peace of mind. This is something that can really weigh you down. And make sure you feel free to reach out to me if you need to. And if it's not me, I can definitely refer you to other people in other states if necessary. I'd be happy to. So if anyone has any questions, let me know. And in the meantime, I'll stop sharing.
No, keep sharing. Well,
Keep sharing.
Yeah, wherever you want to be comfortable with.
Where
But
am
we
I
did
at?
have one question earlier in the presentation regarding the difference between the requirements for the will for Florida and other states.
Oh, well, I'm only licensed to practice in Florida, so I could tell you what the requirements are in Florida. Not for you to go online and find a will online that matches the requirements, but for you to really be mindful of all the different things that comes into putting something like that together. There's a lot of different pieces to it, but I can definitely tell you what is involved. As far as Florida, it has to be written, usually typed up, can't be handwritten. That's called a holographic will, and that's not valid in Florida. Your will has to be signed by 2 witnesses. I recommend, in order to avoid any possible disputes, that it's 2 disinterested witnesses. That means not the personal representative, not the beneficiary in it. I've seen wills where it's signed by the person who's getting everything, and I'm like, why would you do that? Or, it's being signed by the personal representative as a witness. Those can always bring up some questions and may also be challenged by the people who don't want the will to survive, right? Because they may be in line to get that will. The other thing is that it must be signed at the end, right? Usually what estate planning attorneys do is on that last page, it says this will consists of X number of pages, so that you're signing it at the end of that X number of pages. So we'll say this will is consisted of 6 pages and you're signing it on that 6th page. Usually a notary public is involved, but it's not required. But here's why having a notary public involved is important and good, especially if all you have is a will and your entire estate is going through probate. So you have to get it authenticated, right? The will has to be valid. In that case, one important thing to do is make sure that there is an affidavit a self-proving affidavit, which means after the will is signed and the 2 witnesses signing saying that they signed it in the person's presence, they signed it in each other's presence, and they signed it in the present, their presence, our presence, and the presence of each other. So everybody signs it altogether, and there only needs to be 2 witnesses. So the pandemic really pushed that question.
Mhm.
And I've seen a lot of wills get thrown out because the person who was in the hospital signed it, the will transferred to another room and got signed by witnesses, and then transferred to yet another room and got signed by a notary. That's an invalid will. One of the things that us estate planning attorneys got really good at is finding a glass window so everybody can see each other, even though they may not be close to each other. That is so super important. But back to the affidavit. The affidavit is also signed by the testator or the testatrix and the 2 witnesses. But this time it's also notarized, saying that the notary public saw that person sign the will and then saw these 2 witnesses notarize the will. So that means the notary public cannot be a witness, right? Because you can't notarize your own signature.
Mhm.
So that's at least 3 other people in the room with the testator or testatrix signing and witnessing that will. That affidavit is very important because when you bring that will to the court and there's no affidavit, a witness has to come to court and tell the clerk exactly what's in the affidavit. That I saw this person sign the will. I signed it in their presence. I signed it in the other witness's presence, and we signed it in the presence of everybody else. What if that witness later on, after that person dies, decides that's not what they remember, or they're just not going to court? They may be in Alabama now. They're not trying to, or they can't get up, or they're in a nursing home. All of that stuff makes having that type of affidavit super important. It really resolves a lot of issues. But sometimes these notary publics don't be signing things right, don't be filling out things right. That will also kick your will out of the court. So be really careful when you're putting something like this together. And us attorneys, if we're the ones creating it, have to make sure that all of those dots and checks and I's and everything is done properly, because if it's not, that will is not valid. Just for a notary public signature being or something being filled out wrong, the whole thing gets tossed out. So that's super important. That's a really important thing to know about the requirements of the will in Florida. Thank you for that question.
No problem.
Any
We
other
have
questions?
one more about outside property. Is that something that goes in the trust? Even though you may have IRS 401ks, bank accounts that have beneficiaries, but not the outside property.
Oh. If I understand that.
You can kind of look down in the chat, Mr.
Okay,
Tyrone, or
let
Mr.
me jump.
Tyrone can come off mute and accent himself if I'm missing it.
Sorry, I can't. I was trying to make sure I got to the chat. Let's see. Thank you. Is the trust something to do if okay, I'm still not clear. So you're asking if you should still do a trust if everything else has a beneficiary because you have outside property? Yeah. I mean, the beneficiary stuff, I'm always nervous about beneficiaries, right? Because an estate planning attorney has to plan for everybody's death, not just yours. You can't assume that someone would not dare die before you. My sister thinks I should not dare die before her. She does not want to go through the grief, but you really have no control over what happens in another person's life. And if it's not important to you what they do with the money, how they spend it, then yes, a beneficiary is good. But if your beneficiary predeceases you, it's going to your estate, and your estate has to go through probate. So consider all of those things when you're thinking about beneficiaries. Sometimes the stage and age in your life is different about whether or not you put one or more beneficiaries on an account. With brokerage accounts and IRAs and life insurance and stuff like that, you can really split it up into percentages, amounts, and things like that, depending on what kind of company you're with. But when we're talking about outside property, yeah, you have to go to probate. I mean, and sometimes it's like multiple things going on. The person moved from a different place, moved here, became a Florida resident, then died, was renting down here, but had like 3 or 4 properties, other places all over the world. You still have to start probate here and probate each of those places in the counties that those places are, and be subject to whatever clerk of court and county jurisdiction has to offer. So I still recommend that if the assets that you have require beneficiaries, that you make a trust and have everything going to the trust so you can control what happens to it and protect the people that you're leaving the stuff for. But also, if they pass away, you have a contingent beneficiary in your trust already lined up. So it's not going to go to waste. It's not going to be bounced around in different probates. And you can make sure that the people that you want to take care of are covered. I hope that answered the question. Does anyone have any other questions?
I don't see any more in the chat. Ladies, you can feel free to come off mute. If not, tell us our next steps and how you can help us.
Sure, absolutely. I'm hoping that this will work.
Okay.
Okay, so what you can do is you can schedule a legacy planning consultation with me. And you do so by going to my website, and I'm going to drop that in the chat right now. Ooh. Sorry, y'all. I had to restart my computer. Drop my website in the chat. But I'm also going to put all of my contact information in the chat as well, so you can find out more about me and my firm. But because you took the time to sit with me today, and if you're not already a client of mine, then you get to meet with me for a free up to 90-minute personal legacy planning consultation. And all you have to do is refer to the fact that you attended one of the Rhonda's Promise resource table events, and we'll definitely get you in for free. My personal legacy planning consultation is usually $450, and some people pay it. But if you decide, usually if you want to share my information and see if anybody else would be interested in working with me, they get the same type of benefit of coming to the consultation for free, but they go to my website and watch one of my pre-recorded webinars. Also, I have an in-person seminar coming up on October 17th. It's being held at the Hilton Garden Inn, and that is a free seminar as well. And I can provide you, the website will have more information about that, or you can call or have your friends call the office to get them scheduled for that as well. Let me drop my information in there.
And thank you so very much for taking the time out this evening. This was so beneficial. I learned some things that, every time we talk. So I really appreciate you sharing your knowledge with my viewers and my clients. I really thank you for that time. And Rhonda's Promise, our next event will be October 27th. It's going to be our skate party for a cause, our Halloween skate party. So if you have not gotten a chance to register for that, please do. And if there's nothing else, we'll call it a night and give everybody back their time.
Thank you very much for allowing me to come on and present to everyone. Let me stop sharing now. Thanks for everyone allowing me to come on. It's been a pleasure. And thank you so much for your energy and support. I hope this was really helpful to you. And I hope that you will take advantage of the consultation and share my information with anyone who needs help with estate planning, elder law, or probate help. Thank you. Have a great evening, everyone.
No, thank you. We see you October 17th and then again on October 27th. Good night, everyone.
Bye.